If someone in your family passed away with no will and now there's a house sitting in limbo, you're not alone. More than half of Americans die without having a will. But the good news, you can still sell the house legally if you follow the right steps. Here's how to avoid legal problems, how to get the property sold, even if there's no will, no probate yet, and multiple heirs involved. When someone dies and there's no will, it's called interstate. That means the state will decide who inherits the house according to their laws. Here's the basic order in Texas. Your surviving spouse gets a house. If they're not alive, it goes to parents/siblings, and then it'll go out to extended family. But just because someone should inherit the house doesn't mean they have the legal right to sell it, and that's where probate comes in. You can't sell the house until someone has authority. You need someone with legal authority to sign off on selling the house, and that's where the probate court appoints an administrator. Here are the steps to start probate. Step 1. File an application for probate. Step 2, ask to be named an administrator if you are a family member. The court will issue letters of administration. Now you can legally sell the house. In my experience, this process is going to take up to 6 months. The best way to do this, guys, is just hire a probate attorney or a real estate attorney. If there are multiple heirs, things can get more complicated. Everyone has to agree on the sale and sign off on the paperwork. Here are the common issues. One heir doesn't want to sell. You can't find all the heirs. One heir is deceased and has heirs of their own. I've seen people lose houses and not be able to sell because they could not find an heir. Remember the state laws? So if the house goes, let's say, down to extended family and there's extended family you can't find, that person actually has to sign off on the property in order for it to be sold. This is where a title company or a probate attorney becomes critical. They will help verify heirship and navigate the messy family trees. Ask a title company if you can do what's called an Affidavit of Heirship if probate has not been started yet. It's been years and no one filed probate. You still have options, but it gets harder over time. File probate now if it's not too late. If a person passed over 4 years ago, you may need to do an heirship determination. In Texas, some courts accept small estate affidavits for houses under a certain value. This is where an experienced attorney or an investor-friendly title company comes in. They can help you fast-track the process and give you a creative solution. Yes, you can sell the house even if the probate is not complete, as long as the administrator has full authority to do so. Here are the requirements. The buyer must wait for court approval or the title to be clear. The title company must be experienced in probate deals. All heirs must sign off and cooperate if required. If you're selling to a cash investor, they can usually handle most of the paperwork, help you navigate probate, and work with the title company to speed things up. Here's the fastest way to sell a house without a will. If you're overwhelmed, here's the fastest way to sell a house without a will. Find an investor-friendly title company, file for probate or ask for an affidavit of heirship. An affidavit of heirship is going to be the quickest. This can be done in less than 30 days. Get an agreement with all the heirs if applicable. Sell to a cash investor who can close quickly and let the title company coordinate the rest. If you need an investor-friendly title company, I can give you some recommendations. If you are in Texas and you need a cash offer on your property or you want some recommendations on attorneys, title companies, click the link in the bio or comment below and I will give you those recommendations.